Georgia just passed the most significant HOA legislation in the state's history. It's on the governor's desk right now, and all signs point to it becoming law. And if you sit on a board, whether you manage a single-family HOA, a condo association, or a property owners association, this law is going to affect how you operate. I'm going to walk you through exactly what it is, what it requires, and what you need to do about it. Picture this: a 77-year-old man in Kennesaw, Georgia, retired, Social Security. He gets a letter. His HOA is moving to foreclose on his home. And the reason, they state, he didn't pressure wash his house and he left a ladder and a bucket outside.
One man's HOA battle regarding pressure washing fines could cost him his home.
Everything I had is tied up in this house, all the equity I've got to show for my life.
Under Georgia law, as recently as a few weeks ago, that was completely legal. An HOA could foreclose on your home the moment an unpaid fine or fee exceeded $2,000. No state agency watching, no place to file a complaint, no oversight of any kind. Across the state, an investigation called HOA Nightmares was documenting what that actually looked like. They surveyed nearly 200 Georgia homeowners dealing with HOA issues. 63% of them owned fines and fees. The average amount, more than $8,000. Nearly 40% of them are in active lawsuits, most of them carrying liens on their homes. All of this with zero universal state law governing any of it. Zero. Well, that's all about to change. To understand why this law matters, you have to understand how Georgia was different from many other states. When it came to HOAs and condo associations, Georgia was essentially the Wild West. Most states have some form of mandatory oversight or registration. Georgia had none of that. Once you filed your incorporation paperwork, the state essentially stepped back. Associations operated almost entirely under their own governing documents, their covenants, their bylaws, with no ongoing oversight, no required annual reporting, and no place for a homeowner to go with a complaint short of hiring an attorney and taking it to court. But here's the thing, most boards weren't abusing that. Most boards were doing their best. Volunteer board members working full-time jobs, trying to maintain property values and enforce reasonable rules. I've heard from boards like that all over the state. But the absence of a framework created a vacuum, and some associations filled that vacuum in ways that ended up on the news.
We saw a lot of familiar faces at the Capitol today. You know, we've heard from hundreds of homeowners having problems with their HOAs just in the last year.
HOA Day organized by Representatives Viola Davis, Kim Schofield, and Sandra Scott, as well as Senator Donzella James.
They don't follow their own rules and bylaws.
In February of this year, dozens of Georgia homeowners packed the Capitol for something called the HOA Advocacy Day. They were pleading with lawmakers to do something. A bipartisan group of senators, led by Senator Matt Brass, a Republican from Noonan, and co-sponsored by Donzella James, a Democrat from Atlanta who'd been pushing things like this for years, had a bill ready. That bill, Senate Bill 406, passed the Georgia Senate unanimously, 51-0. Then it passed the House 155-10. On March 31st, it went to Governor Kemp's desk. They named it the Georgia Property Owners Bill of Rights Act. But here's the thing that nobody's saying clearly enough. This bill isn't just about protecting homeowners. It changes what boards are required to do. And if you're not ready, it will affect your association's ability to collect assessments, place liens, and enforce your governing documents. In short, you essentially lose any real power to govern the community. So buckle up, because that's what we're going to break down right now. Let's go through these systematically. 6 major changes. Number 1, mandatory registration. Every HOA, condo association, and property owners associations in Georgia must now register annually with the Georgia Secretary of State. The fee is $100 per year. Here's the part that matters most, and I want you to hear this clearly. If your association does not register, you lose the ability to collect fines, accelerate assessments, place liens, or initiate foreclosure proceedings. All of it gone. There is an opt-out provision. Your board can formally notify the Secretary of State that you choose not to register, but if you opt out, those same enforcement powers go away. This essentially is a mandatory compliance system with an explicit off-ramp that strips your enforcement of any teeth. For Georgia, this is historic. There are an estimated 4,000 plus active associations in the state. Before this law, none of them had state registration requirements. Now, every single one does. Number 2, new foreclosure threshold. The old threshold for foreclosure was $2,000 in any unpaid amounts, and critically, fines and fees counted toward that number. That's how associations could get to $2,000 really fast, sometimes over relatively minor violations. Under SB 406, the threshold is raised to $4,000 in unpaid regular assessments only. Fines and fees no longer count towards that foreclosure threshold. The association can also foreclose if 12 months of assessments have gone unpaid, provided the amount exceeds $2,000. Now, I don't want to lose you there, so I'm going to repeat that. The standard threshold is $4,000 in unpaid dues. The 12-month rule is a separate trigger. If an owner has gone a full year without paying, foreclosure can begin once that amount exceeds $2,000. Either way, fines do not count. Additionally, associations must now give homeowners a 90-day notice period before foreclosure can begin. The notice has to specifically state that paying within that window eliminates the right to foreclose. That's a new due process requirement your governing documents probably don't reflect. Number 3, assessment payment priority. This one catches boards off guard because many governing documents are written in exactly the opposite way. Under SB 406, when a homeowner makes a partial payment, regular assessments must be satisfied first. Before fines, before late charges, before attorney fees, the law establishes a clear payment waterfall. Regular dues first, then special assessments, then specific assessments, then everything else. If your CC&Rs or collection policy currently apply payments to fines and attorney fees first, that document is now in conflict with state law. That's an amendment that needs to happen. Number 4, you now have a 10-year record retention requirement. All financial records must now be retained for a minimum of 10 years. Homeowners gain an explicit statutory right to inspect records upon request. If your governing documents specify a shorter retention period, those documents need to be updated. When you register annually with the Secretary of State, you'll also be required to submit 3 years of financial records along with your governing documents. Number 5, there is now a state complaint board. You heard me right, there is a state complaint board. For the first time in Georgia history, homeowners now have somewhere to take a complaint that isn't just the courtroom. SB 406 establishes a 5-member state board of review of complaints operating under the Secretary of State's office. If a homeowner files a complaint through the Secretary of State, a hearing officer reviews the case instead of it going directly to court. And during an active complaint, collections of fines from that homeowner is automatically stayed, meaning paused, while the process plays out. Binding arbitration is also available. For boards, this is a double-edged change. On the one hand, it creates a structured process that isn't just your word against theirs in court. On the other hand, it means disputes are now handled by a state officer. So your documentation, your notices, your due process record needs to be clean. All right, so there's 2 more provisions worth flagging. On attorney fees, before any attorney fee can be passed to a homeowner in a collections manner, SB 406 requires the association to provide an itemized statement, give the homeowner a 30-day opportunity to pay, and have a judge make a finding that those fees are reasonable. Blanket attorney fees in your governing documents is going to conflict with this. The attorney fee provisions actually take effect earlier, July 1st, 2026, for any new legal actions filed on or after that date. Now, onto elections. Registered associations must hold annual board elections with formal procedures, electronic record keeping of ballots, and state filing of election results. That's a new administrative layer for most self-managed communities. So let's talk about what this actually means for you as a board member. The short answer is you have a window of time, and you should use it. The full law takes effect on January 1st of 2027. The attorney fee provisions go live July 1st of this year. That gives you some time, but not an unlimited amount of time, so I would get on it quickly. Here is what responsible boards should be working through right now. First, decide if you're going to register. If your association relies on dues, fines, or the ability to enforce governing documents, the answer is almost certainly yes, you're going to have to register. Registration is $100 a year, and it's what keeps your enforcement powers intact. Second, pull your governing documents, your CC&Rs, your bylaws, your collection policy, and review them against the new law. Specifically, look at your payment priority language, your foreclosure threshold references, your record retention policy, your attorney fee provisions, and your notice procedures. There are likely several provisions that are now in conflict with state law. Third, get your financial records in order. The law requires 10 years of retention. When you register, you submit 3 years. If you don't have that history organized, now is the time to fix it. Fourth, review your collection and enforcement process for the new notice requirements. Before any fine accrues, homeowners must receive written notice with a specific citation of the violated provision and a cure period. If your process doesn't include that documentation chain, you need to build it. Fifth, talk to your association's attorney. This is the moment to have that conversation before you're registering under pressure or responding to a complaint. I want to say something to boards directly because I know this audience. Most of you volunteered for this. You didn't sign up for a full-time compliance job. You signed up because you care about your community and you want to protect property values and maintain a place that people are proud to live in. That's the real thing, and this job is much harder than people actually realize. This law wasn't written to punish good boards. It was written because some boards operated without guardrails, and unfortunately the absence of a framework made all boards look like them. Boards that are going to come through this cleanly are the ones who are organized, transparent, and running their association with documentation that holds up. That's always been the right answer. SB 406 just makes it the legal requirement now. Before I wrap up, I want to make sure you know what you're actually dealing with here. What SB 406 is really asking boards to do is demonstrate that you're running a legitimate operation. That means documented processes, accurate records, proper notice chains, and the ability to show your work if a complaint ever lands at the Secretary of State's office. And if I had to guess, a lot of self-managed communities in Georgia are doing good work, but they don't have a system that makes any of it easy to prove. Combing through text threads and Google Docs is not an ironclad solution. It seems to me like getting organized before the deadline rather than scrambling when the law goes live would make this whole thing a lot less stressful, but that's something that you would know a lot better than I would. What I can tell you is what we built Solume to do. Solume is an all-in-one management platform designed specifically for self-managed HOA and condo communities. Not a property management company, not a system that assumes you've hired someone to run your association for you. It's built for boards like yours. It's built for you with laws like this in mind. Document storage, dues collection, violation tracking with documented notice chains, maintenance requests, communications, budget management. It's all in one place, built around the way a self-managed board actually works. And yes, it includes a reserve study management built directly into the platform, which most platforms treat just as an afterthought if they even address it at all. Georgia's rule just changed. For the first time, HOA and condo boards in this state are going to operate inside a regulatory framework with real accountability attached. The boards that treat this as a problem are going to have a harder time. The boards that treat it as an opportunity to show that they were running things the right way all along, they're just going to adjust just fine. I'll put a link to the full text of SB 406 in the description, along with a summary checklist so you can bring to your next board meeting. If you found this useful, share it with your board. They need to know this information as well. I'm Joe Braun, thanks for watching.